Indira Jaising is not just a senior advocate. She is the reason why we question how seniority is earned. A crusader for transparency in senior designations, and the first woman to be designated as a senior from the Bombay High Court. She has been pursuing this cause of senior designations relentlessly. She has perhaps shaped this entire debate which the Jitendra Kalla judgment delivered by the Honorable Supreme Court in the last 1 week now reignites. There is perhaps no one more relevant to this conversation and to this moment than Senior Advocate Jaising. Thank you, ma'am, for being with us.
Pleasure.
The recent judgment critiques the interview component of the designation process. Could you clarify your original stance on the interview component in the senior designation process as a mode to evaluate candidates, and what alternative methods would you suggest?
So before I answer your question, I'd like to go back to the original inspiration for filing it. As you know, it was a judgment delivered by 3 judges, and by that time, I had observed that designations are made in a very elitist manner. I would notice that only those who are very close to the judges, either as sons or daughters, or who have access to the judiciary, would get designated, and others were not getting designated. This is what motivated me to file it. Moreover, I must tell you, and I'm sure you're aware of it, that the system has changed worldwide, more particularly in the UK, from where we seem to have borrowed the system of senior counsel under Section 16 of the Advocates Act. And my hope and my desire was that there should be transparency in the way in which people are designated, the why of it, why designate someone. So the big question really is, do we really need this distinction between designated and non-designated lawyers? And if the answer is yes, then there has to be something about a person who is designated which is different from a person who is not designated. And I would say for that it is issues like the ability of the lawyer to maintain a certain ethical conduct, the ability to rise above the brief in question, excellence in knowledge of law, ability to actually tell a judge objectively what the law is. I also believe that lawyers should cite judgments which are against them. You do not indulge in sharp practices, but most importantly, equality of opportunity. This is why it was filed. Now I can answer your question about the interview. Generally speaking, I do not believe in the ability of an interview to tell you anything about a person. And normally interview marks are used, from my understanding and from my knowledge and my experience of having worked extensively on service law and labor law. I had noticed that the component of interview is often used to kick up or kick down someone. Okay. And that is the reason why in my original suggestions which I had made to the court, there was no component for an interview. So when the judgment was delivered, Justice Gogoi did announce in open court that he had put 25 marks for interview, and I did get a bit of a shock because 25 out of 100 is a bit too much for an interview and leaves enough ground to manipulate. You know, if you want, you can, a person who doesn't make the grade in terms of years of service, in terms of the nature of judgments, can get a 25% addition to kick the person up. And so I did draw the attention of Justice Gogoi to this, that where did this interview component come from? To which his only answer was, the judgment has been delivered, no further discussion will be entertained. So that's as far as the interview is concerned.
Did any lawyer specifically argue the interview component during the hearing and seek a 25% allocation for the same?
Not at all, not at all. So having said that, I would say that it would be reasonable if any 100-point index wanted to have an interview component. However, 25 marks is far, far, far too much for that, even if you do want an interview. First of all, the interview should have substance. So this time when I was arguing the matter before a bench presided over by Justice Oka, he put the same question to me, what's the purpose of an interview? So I said, well, if you wish, as the interviewing judge, you should ask the questions of lawyers which are academic in nature, which are creative in nature. For example, you take acts like the POCSO Act, where the burden of proof is reversed. And if I was sitting for an interview and interviewing somebody, I would ask a question like this, well, oh, Mr. Counsel, Miss Counsel, what have you to say about the reversal of burden of proof in a law like POCSO? Do you or do you not think that it goes against the basic principle of presumption of innocence? And if there should be an exception, on what grounds? Now that's when you're able to test the creativity of a lawyer, that this is what is expected at an interview. But I have been told by people who have been called for interviews that no such intense interaction happens between the selection committee and the candidate.
But so do you think that the interview component left an element of judicial bias into the process?
Yes, I have no doubt about it, but I'm not able to substantiate it because the mark sheets are not published. They're not in the public domain. But the very fact that you put such a large component for interview allows any kind of manipulation. So I would say even if interviews are to be retained, the number of marks assigned for interviews should be reduced.
Ma'am, the court in this judgment by Justice A.S. Oka-led bench has said that lawyers must possess subjective qualities like ability and standing at the bar. My question to you is, for designation, how can these criteria be quantified?
So, with great respect, I feel that the bench presided by Justice Oka has simply not understood this issue. While agreeing with everything that he says in terms of what is expected of a lawyer, you hit the nail on the head by saying, how do you quantify it? Now, what I want to tell you is that worldwide, and certainly in India, whenever there is a selection process, the desirable qualities are always quantified in terms of marks. You take any selection process. Let's begin with the Indian Administrative Services. How do you decide who makes the cut and who doesn't make the cut? So you have your set of questions or knowledge required, and then you have the marking system. What is a marking system? It basically allows you to quantify a criteria that you're looking for in order to decide whether on the totality you make the grade or don't make the grade. So you take anything, you take the Indian Administrative Services, you take entrance examinations to law colleges, you take entrance examination to medical colleges. Everywhere you go, you have a marking system. Why? Because it's a selection process. So no matter what criteria you use, ultimately those criteria have to be quantified. And the only way you can quantify them is through a marking system.
Which brings us to the next question. With the Supreme Court having done away with the marking system, what other objective criteria can be used to determine the suitability of a candidate for senior designation?
I'm sorry, but this judgment is not the last word on the subject. So I do not wish to discuss this on the assumption that this is how designations are going to be made in the future. There is going to be a prolonged legal process before we arrive at what should be the process. And Justice Oka himself has said, put a moratorium on all designations for the time being until guidelines are laid down. So A, we need to wait and see what those guidelines are. But apart from that, I would like to say that this bench of 3 judges has undermined the basis of the judgment of a coordinate bench of 3 judges. I believe that the bench had no jurisdiction to do what it did. And I believe that if the bench did want to undermine the basic structure, the substratum of the judgment, they had a duty to refer it to the Chief Justice for a reference to a larger bench. So the question you asked is capable of multiple answers. Number one, we wait and see how high courts are going to do this. Number two, will there be a review petition? Number three, will there be a curative petition? Number four, will there be a petition under Article 32 challenging the constitutional validity of Section 16 as being completely arbitrary, unguided discretion? Right. I believe that this judgment has taken us 10 steps backward, back to a regime where it's going to be what we used to call face law and not case law.
So do you think the judgment should be set aside?
I certainly do. The question of, however, is what is the process and also what will replace it.
Ms. Jaising, will you be filing for a review?
I am contemplating my options, but I can tell you this much, that if you have an opportunity to read my original petition, you will find that the basis of that petition was equality of opportunity and equality before law. I'm proud to say that after the judgment, the doors have been opened to designation. I'm also proud to say that a huge number of people, both men and women, have been designated. And I'm aware of this argument that, oh, you know, not everybody who's designated has the necessary qualifications. Well, I would like to ask the question, how many people who were designated before the Indira Jaising 1 judgment had the necessary qualifications? Yes, they did have the qualifications of being kith and kin of judges. They did have the qualifications of being high net worth individuals. But did they have the qualifications of being worthy lawyers? That's a question to be asked in relation to the pre-Indira Jaising 1 judgment. And I feel that it is my duty to introduce a democratic system of functioning at my workplace. And my workplace is the courts, whether it's the High Court or the Supreme Court of India. And I saw what I did as the process of democratization of the bar. And I think the purpose was achieved, notwithstanding the fact that large number of lawyers were getting designated. One thing, of course, I would like to say, we have seen people being designated who have had a track record of indulging in sharp practices. I believe Rishi Malhotra is the person against whom these allegations have been made of sharp practices. I certainly would like to ask the question, which court designated him? It was this very full court, okay? Can they answer to the question, how did you designate somebody? Why put the blame on the system of designation? The judges also need to look a little inward and decide for themselves, where did they go wrong?
You know, this brings me to a very important question. Do you think this entire Rishi Malhotra saga had a casting shadow sort of an effect on this particular judgment being delivered? Do you think it kind of influenced the judges so as to say, beyond the arguments, to deliver something that you put it as that, which takes us 10 steps backward? Do you think that episode had something to do with it?
I have no doubt in my mind about it. And the fact of the matter is, even today, judges are willing to tolerate sharp practices at the bar. Why? Why was somebody, this is not about Rishi Malhotra, it's about ethical practices or unethical practices at the bar. They're tolerated. Why? There is a duty cast on the judges also to ensure that the legal profession functions according to certain norms, according to certain rules of conduct. And when you allow those standards to get eroded, I blame the judiciary more than the legal profession. Of course, the legal profession must self-regulate.
So, was this a tragedy of generalization? Like the Yashwant Verma controversy cannot, of course, cast a shadow on the doubt that all judges in the residences have, cash stacked. Of course, it's an allegation as of now. But should the Rishi Malhotra episode also come to be generalized in a fashion that such a judgment has been delivered, according to you?
See, I don't think it's that. I think it's the numbers of people who were designated, which has created a sense of panic in the judiciary. And as far as the numbers are concerned, I would say the more there are, the more welcome they are. Right. And you notice a really interesting change. I notice a very interesting change in people who are designated, one day before designation and one day after designation. I think what designation does to people is it also enables them to improve their own standards of advocacy. It gives them a sense of confidence. It also makes them far more responsible as lawyers being officers of the court. Right. You do consider yourself an officer of the court when you're designated. So I, for one, have never had any complaints about the facts that large numbers are being designated. All right, if there are a large number designated, there will be some who are better than others, but that's the name of the game. You have to take it as it comes. And in the ultimate analysis, there is a legal market out there which really regulates whether a particular person is going to get briefed or not going to get briefed. So why is everybody so worried about the numbers? I don't get it. If you're not a good lawyer, nobody's going to brief you. If you are a good lawyer, you will get briefed.
Right. You have previously expressed concerns about the lobbying process that happens or influences the designation process. What measures would you recommend to ensure transparency and fairness, particularly with respect to lobbying?
Yes. See, one of the things that I made clear while arguing, and I'm very glad that it's been recorded and I think made part of the law of the land, sitting judges were giving recommendations to individual lawyers, recommending them for designation. That is the highest form of lobbying. And that I was very keen that should be stopped. Now, apart from that, lobbying is a fact. And I was a bit surprised that the learned Solicitor General, Mr. Tushar Mehta, actually agreed with me when I said that lobbying goes on. I don't know his reasons, but I know my reasons for saying it goes on. Particularly in cities like Delhi and the Supreme Court, in the whole capital territory of Delhi, which is heavily influenced by, I would say, politics. I think lobbying, sycophancy, and partying, and striking individual relationships with judges of practicing lawyers is very common. The other thing that I find very disturbing, of course, is that the kith and kin of sitting judges, you'll find them practicing all over every court. Right. And just by their look and feel, you can tell that, this is a person who is well connected with the judiciary. And all this has to change. You can't just change the method of designation and hope that the system will change, become more democratic. And in that sense, what I tried to do was just a drop in the ocean. There are many other systemic changes that need to take place. Now, at least, they've decided, the collegium has decided to put on record people who are related to each other within the judiciary. Right. But we need to go a step further and put on record who are the children of judges who are practicing, with whom, in whose chambers, and where. Exactly. I mean, you have kith and kin of judges practicing in the chambers of law officers, okay? And those law officers are appearing before the Supreme Court day in and day out of their lives. So how can you claim that your system of administration of justice is, I don't know the right word for it, whether it's fair, I would say this is an unethical practice.
So even now, kith and kin of Supreme Court judges are practicing in law officers' chambers?
I'm sure about it. Yes, I think so.
The judgment calls for more senior designations of lawyers practicing in trial courts and tribunals. How will that work in practice? This particular direction has been hailed by all sectors of the country. So how do you think this entire process of trial court designations work?
See, while I agree that there are very good trial court lawyers, I don't want to sound patronizing, but I can tell you that I started my practice in a trial court. I started in the labor courts, and I actually believe that if you work your way up from the bottom to the top, you are going to be a better lawyer than any other lawyer. So, in principle, I agree. But the big question is, how do you identify these people? I don't think you can have any certification by any authority for that. It doesn't make sense. It's contrary to what the judgment is otherwise saying. But I know that very many trial court lawyers practice in the high courts, and I'm aware that high court judges will definitely know who is a good trial court lawyer. So I would expect trial court lawyers to be designated by high courts. I think that is a welcome change.